You know you have a great case. You decide to sue your doctor for medical malpractice, that he was careless and caused you significant harm and injury. When you start your lawsuit, how is it that the judge and the defense attorney know how great your case is? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I have a few minutes to share some great information with you on this brief walk around the neighborhood. And now, here's the question. When you go ahead and start a lawsuit, you know in your heart of hearts that you have an excellent case. A medical expert has already confirmed that your doctor was careless and caused you significant harm and injury, and that carelessness was a cause of your injury and that your injuries are significant. So now, you know this, your attorney knows this, the medical expert who reviewed your case knows this, but when you start the lawsuit, how is it that the judge knows this? How is it that the defense attorney knows this? And you want to know the answer? They don't. They know nothing about your case. The defense attorney knows absolutely nothing. All he knows is that you have served certain legal allegations against the doctor whom you have sued. All the defense attorney knows is that he's received papers about allegations that you have made against your doctor. These are generalized legal allegations that don't really give him the facts and don't tell him specifically exactly what happened and why you have such a great case. Likewise, when we notify the court that now we have a case that's active, the court doesn't yet know what the facts of the case are. They don't know the details. They don't know how great your case is. So what happens? During the course of discovery, it allows us the opportunity to learn more information about exactly what was done by the various witnesses that were involved. Likewise, the defense has an opportunity to gather your medical records. And how do they do that? They do that by requesting permission slips from us that will allow them to go ahead and get your medical records directly from the doctor. And you should know that we are still obligated to provide the defense with copies of whatever medical records we have already obtained. So we provide it to them, and now we're also obligated to tell the defense attorney, hey, listen, here's a detailed, itemized list of exactly why we believe we have a very strong, credible case. It's known as a bill of particulars. And in that bill of particulars, we are obligated to itemize and detail exactly why we believe the doctor was careless, why we believe that his carelessness was a cause of your injury, and now we have to itemize the extent of your injuries and those things you can and cannot do. The doctor failed to do this during the course of surgery, and because of that, you now suffered the following problems. And because of all those problems, you were out of work for a period of years, and now any other injuries or damages that we are aware of, we have to tell the defense attorney as well. So now the defense lawyer gets that information, and they say, you know what? I don't know whether what you're claiming is true or not. Prove it. Give me those documents. Let me look at it for myself. So we actually have to do that as part of the discovery process. So we give the defense those documents, and we give them permission slips known as authorizations to go ahead and get those records on their own. After they accumulate those records and go through that, now they'll have a better understanding of how good your case really is. So now let's get back to the second part of the question that I asked. How does the judge know how good your case is? And the answer is, he doesn't. But you should know that from time to time during the course of your lawsuit, the attorneys are going to come into court to give the judge an update on what's going on with your particular case. These are known as compliance conferences or status conferences. The judge wants to make sure that we are providing the defense with all of the appropriate documents needed that they need to evaluate your case, and likewise that the defense is providing us with any documents that we want as well, and that we're on schedule and on track to get this case moving forward. And invariably, there are disputes that arise amongst the attorneys saying, listen, judge, he's not entitled to receive 15 years worth of medical records. This only relates to a period of time 2 years before this instance happened. The judge will resolve the disputes that arise among attorneys about the discovery that has to be exchanged, in addition to resolving those discovery disputes. But in most cases, the judge is not going to have an opportunity to give us the time necessary to go ahead and fully get involved in our case. Why? Because he's got a full caseload and he sees hundreds of cases a week that he now has to deal with. So how does the judge really know that you have a great case? In all likelihood, when your case is ready for trial, the judge will ask the attorneys to come in for a settlement conference. At that time, he will have more time to spend to listen to what the facts really are and to put pressure on both sides to see if they're willing to negotiate and resolve this before going out to trial. That's the most likely time that the judge will really get an understanding of what's going on and how good your case really is. So why do I share this quick information with you? I share it with you just to give you a sense of what really goes on in these medical malpractice cases in New York. You know, I do realize you're watching this video because you want to see the beautiful scenery. No, I understand you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.